Hello, everyone. My name is Joshua Gilliland, one of the founding attorneys of the Legal Geeks. I was wrong that last week was the penultimate episode. Eight's
Me
a good
too. Yeah,
eight's a good number. I didn't expect it to be nine. That I was wrong. So this is the penultimate episode, and boy howdy, is it a good one. With me to discuss it is the retired Judge Matthew Sherino from New York, now in Florida, and Gabby Martin. So, Your Honor, how are you this evening?
I am well, thank you.
Excellent. And Gabby, how are you?
I'm doing good. I think in addition to all the legal issues in this episode, which we'll cover, the filming on this episode was incredible. Like they put in some extra work with their cinematography this episode.
Yeah, the
Um,
cinematography, especially in the black and white ball. I mean, like
mhm,
their outfits popped when he came out in the his signature white tux. It was I agree, Gabby. It was
yeah.
really good cinematography.
Yeah, I'm still stuck on the change in aspect ratio when you get to the end, which I guess we're putting up a spoiler alert at the end. But that aspect ratio change was very cool and still thinking about it, so loved it.
Yes. So, the Island of Joy. I have a lot of joy. It was exceptionally well done and packed full of legal issues. So, out of the gate, we start with a taking a prisoner. Normally, when someone is in I was a police officer or law enforcement, federal agent, what have you, and they go to prison, they're isolated from general population to avoid getting killed. And they do that with Bullseye because he's a former federal agent turned hitman assassin. And they put him in general population. Your Honor, I think you have some notes on this that help us understand the problems with this.
Yeah, there was a little bit of a mixed message in the episode itself when Matt was told that Agent Poindexter was moved to Gen Pop by his partner. She kind of mentioned federal holding areas as opposed to I believe the Island of Joy is meaning Rikers Island, which is where they keep city uh, prisoners, although after he would have been convicted, he would have been transferred to a state facility, so he wouldn't have been on Rikers Island after he was convicted of a felony. But for the episode's sake, it looks like he was on Rikers, so we'll discuss Department of Corrections. And for the most part, Department of Corrections does have carte blanche with regards to the transferring of prisoners to and from the various facilities, and they can transfer people to and from the various parts of the island, including from protective custody to Gen Pop, general population, at their whim. And it seemed that this was done at the behest of the mayor. Uh, the mayor um, generally would not have the ability to force Department of Corrections to house someone one way or the other. Um, Although they could, of course, put in a request. So I think this was an overreach from Kingpin um, in order to probably result in Bullseye being killed so that he wouldn't be able to ever say anything bad about the mayor.
Just problematic. And I get playing fast and loose with federal jurisdiction versus state jurisdiction, and because there are federal and state crimes that Bullseye did commit. It also season three ended with him getting a new spine, which those don't just magically happen. So was he an assassin for the US government? Like, what? There are a lot of unknowns, things that we don't necessarily need answers to. But it's like, for those who think about it, it's like, how? I mean, lawyers like the procedural history to know where we are. It's like, what's the procedural status? And this kind of skips all of that, which makes us go, Is he in a state facility or federal? Because what's happening here?
Right, and
Gabby,
for the entertainment value, I understand it as well. You know, they can't get into every little nuance like we can, but that's one of the wonderful things that it gets us to be able to talk about.
yes. Gabby, your thoughts?
Yeah, I'm curious now that you say that, and I'm wondering if the judge has any thoughts on this. If because obviously we find out by the end of the episode that it's not necessarily Fisk, it's Vanessa. And obviously, a spouse of a mayor really has no, it's not like a first lady, right? Like a first lady would have the office of the first lady and, maybe a little bit more like political sway or power, right? There's no office necessarily of the first lady. I don't believe in New York City or any on municipal levels. Um, it can a private citizen then, if kind of put in the kind of same request with the Department of Corrections to move such and such an individual from one to the other.
Yeah, no, a private citizen wouldn't be able to, and uh, in a lot of cases where someone's in protective custody, they're the ones that actually ask to go to um, the general population because the protective custody is doesn't have a lot of the same facilities. It doesn't have like, movie night, and it doesn't have the recreation areas, and it's if you're in real protective custody where you're not seeing anyone else, you're could be quite lonely. So a lot of people do request to be out of the protective custody into Gen Pop. But yeah, as you said, most first ladies of the city don't have. They do have a small office. They have a press secretary. They have a chief of staff. They have some other people in the office because the city of New York is so large. It does have a budget for same. And in some mayoralties, the spouse of the mayor have taken on various roles. So, like Bill de Blasio, who was the mayor before the current mayor, his wife was in charge of a mental health initiative for which about $8 or $9 million disappeared. But, that's a crime story for another day.
Yeah, that's a detail. Yeah, some accounting needs to be done there. But be that as it may, first ladies don't get to put out a hit on an individual. That's not they're not elected to anything and they don't get to do summary executions. That's not no, that's not be best. Now we do have Bullseye wanting to talk to Matt Murdock. Raises some interesting privilege questions. And there are notes here. So, Gabby, is this you?
Yeah, because when this question kind of caught me, I was thinking about it as well, and it gets to I think the heart of a question every lawyer, like I think probably the minute you graduate law school, if not the minute you start telling family and friends that you're going to law school, you start to get this of like, well, can I ask you for legal advice? Can I talk to you about this and that and the other? And they believe that just because you do now have a JD or you're a licensed attorney, that you can provide legal advice to them, and that whatever deepest, darkest secrets they confess to you are confidential. But that's just not the case. And so we have attorney-client privilege, right? That does protect the confidential communications between a lawyer and their client that, and this is key here, that relate to the client seeking of legal advice or services. The protection obviously extends to any information exchanged during these privileged communications, which encompasses, as we know, not only what you and the client talk about, but things like attorney work product and that sort of thing, things spoken about in an office between, attorneys, paralegals, et cetera, et cetera. And so we as attorneys are required to not disclose certain confidential information, except with certain exceptions, as we've kind of talked about before. But because this is as New York says is New York Court of Appeals, one seeking legal advice will be able to confide fully and freely in his attorney. That's why we have these confidentiality rules, right? But the key thing is what makes a client, right? This only applies to clients. The privilege actually exists with the client, meaning the client can revoke it at any time. The attorney can't revoke attorney-client privilege. That's something only the client can do. And it really doesn't take hold until the parties have agreed on representation. So somebody coming up to you out of the blue, confessing their deepest, just by us as a virtue of us being lawyers does not make every conversation we have with anybody in the world confidential. There has to be that express acknowledgement in some form of whether it's in an engagement letter, fee contract, right? That's where that whole joke of like handing somebody $1 kind of comes from, that you're engaging them monetarily, right? And you could have kind of other examples of this. You don't necessarily have to have that contract, but the client can't just kind of believe one-sided, right, that there is an attorney-client privilege, that there's confidential information. And I think here, what they're talking about, he's not been contracted as Poindexter or Bullseye's lawyer, right? He's going there just to talk with him, right? There's been no, from what I could tell, any kind of agreement that he's his lawyer. He testified against him at sentencing, right? There's really nothing that would indicate a attorney-client relationship between the two of them. So I don't think what he's saying here is confidential. But that may be, as he says, in another world, Matt would be defending him, right? And it would be an attorney-client relationship, but I don't think we have that here.
I agree we don't have it here, but there are ways it could be created. And like there's always the fear of a Q&A turning into an attorney-client relationship. One of the prior Daredevil episodes had Foggy say like, "Oh, give me $5" or something like that. That doesn't work. That by itself doesn't create an attorney-client relationship. It's a bad trope. It's not the law. But someone asking you questions could turn into an attorney-client relationship. And that's where things get weird, because you have to be careful as an attorney not to inadvertently create that relationship and give advice of, well, I met this lawyer at the bar and he said this, so I went out and did it. I thought it would be okay filing a trademark application this way, like, in something that could turn out to be expensive and wrong, that could subject a lawyer to some liability.
Yeah, and I think that's where you get on in that kind of principle of reliance, and that's why, we're taught, especially when you meet a client for the first time, you express that, what you're talking about initially may not, you're really careful to set up those ground rules of confidentiality. And even now, I don't actively practice anymore, right? But we still have legal brains, right? And so we always have to be careful to say, this is not legal advice. Please go seek counsel from an attorney, from your attorney, from somebody who will be your attorney, right? It's the same thing that doctors do, right? You see doctors on TikTok, on other platforms, they always say this is not medical advice, right? It is not, should consult your doctor before, and that's to prevent a problem, because if somebody relies on information you're telling them, there could be a problem. But it doesn't seem like he's providing any sort of confidential information or relying or seeking any sort of legal advice from that in this case.
Well, I don't think Matt could take Poindexter on as a client because of the testimony and the victim sentencing. I think that could be a huge problem and barrier about, I think going to the duty of loyalty and being able to zealously represent someone. Now, that doesn't necessarily say knock out the entire firm. I think that's a question would take some more analysis on whether or not the firm could take on Poindexter if there was a legitimate reason to do so. And if Poindexter's trying to turn state's evidence or something, like that could be a reason to look at those rules a little more closely. Your Honor, Gabby and I just went down a rabbit hole. Any thoughts you want to add to that?
It was a good rabbit hole, and yeah, absent, really a written waiver of all of the conflicts that Matt and Poindexter would have, he would not be able to represent Poindexter. But Poindexter, I think, if he makes a knowing waiver of and it's he understands all of the things that are the potential conflicts, I think he would be able to retain Matt's law firm to represent him, especially if he was going to come clean with regards to, who hired him to kill Foggy or something along those lines. But yeah, I agree with you 100% on privilege. I don't think that there was ever a attorney-client relationship established, so none of their conversations would have been privileged.
Yeah, it's really hard to imagine the waiver with I killed the managing partner's best friend.
Yeah, no, it'd be a
Yeah.
tough one, but if it was 100% explained to him and he wanted to waive it, and if Matt wanted to represent him, because no attorney can be forced to really represent someone that they don't want to represent, with some exceptions. Sometimes you're drafted on a case, and sometimes you're not let out of a case for particular reasons. But as a general rule, if you're a private attorney, you don't have to take any case that you don't want to take.
Yeah, and I've actually seen that at a couple CMCs where or case ahead of us with one of our matters. It was wild. The lawyer represented a corporation and he lost contact with the corporation. They weren't responding to phone calls, emails, and so he's trying to withdraw rightly, but that raises all these weird issues in California with you can't have an unrepresented corporation in a case. So he's like he was, and the judge was super sympathetic. They were trying to figure out how do we handle this, because if they've gone radio silent and you're trying to do your ethical obligations, like the judge was very sympathetic of like, okay, well, this can't stand, but we also have to figure out a way to not turn the world upside down and how we handle this. So yeah, it can be a real weird thing for when a lawyer has to get out of a case.
Which is
Uh,
why you always need to be careful when you take a case.
yeah, yeah, yep, yep. All right, things they teach you in law school. So one of the things that's always been discussed, whether it was law school or just a practice point, assaulting someone and committing battery is not okay. And Matt deciding to smash Poindexter's face on the table after being goaded by the shackled man, he commits battery, and there are problems with that. And Gabby, I think you explored the notes. And oh no, Your Honor, why don't you take it away? You're both doing a nice pickleball match of back and forth on the issues.
Yeah, this was either assault in the second degree or assault in the third degree, depending on how um, egregious the injury was. If it rises to the level of a serious physical injury, and I think it was bad enough that it probably did, it would be assault in the second degree, which would be a Class D felony, as in David. If it's assault in the third degree, which is simply a physical injury to another person, it would be the Class A misdemeanor. Also would be clear that there was no self-defense or justification argument. The guy was shackled to the table, could not have attacked Matt. So, he would not have any kind of self-defense type of situation. I also thought to myself after um, Bullseye was able to escape, whether Matt doing this was in aid of that escape. Did he know that by knocking his tooth out, he would be able to use that tooth as a weapon? And if he did aid in the escape. He could be part of a conspiracy with regards to escape. And if he wasn't, and Bullseye was just did this on his own because he was in jail for a felony, it would be escape in the first degree, which is a Class D felony. In as much as he had already been convicted of murder in the first or the second, is it would be additional time to his already life sentence. Um, which is why this is the only situation where I am kind of in favor of capital punishment. If you're a prisoner in jail serving a life sentence, I think there needs to be a punishment that can be done to you. So if you kill a guard or a fellow prisoner while serving a life sentence, I to me that's the only justification for a capital offense. But that's a political decision, not a moral one.
So a couple things to unpack. Oh, and apparently me seeing that has become enough of a factor that one of my judge friends has actually used it in court. So I need to be careful with that because I'm now going to developing catchphrases. But breaking down these issues, the battery, because it's the physical touching. Poindexter might have had a plan, whether it was to get a tooth broken or injured in some way so he could make an escape. I don't think there's an agreement from Matt. I think Matt was just angry
Very
because
well could be.
yeah, I don't, because I'm going to the issue of helping him escape. Murdoch would have facilitated an escape that would not have resulted in the loss of life. And the fact that at least two guards die in this process, and one through, I'll say, probably maiming with getting a tooth in the eye. Like that ain't right. Like there's all kinds of levels of bad with how Poindexter just maims people and mutilates. And there are the quick kills and then there are the slow kills. And the guy has such a high body count, he should be in solitary confinement and not allowed to see daylight ever again. Um, Eating with, no sharp instruments. So it's going to be tacos here on out. Uh, even though he could throw one. So again, it's a weird thing, but I don't think there was a conspiracy to commit murder. I think this is all on Poindexter. Also, having gone through root canals, the idea of like breaking a tooth, as the grandson of a dentist, I was screaming inside because that would hurt so bad. And I don't know if there was a root attached to it, so the remains of the root could still be in there. None of this is good. Like none of this is just from a dental perspective, not my lane, but I heard enough stories growing up. That sounds horrible. Gabby. Okay. Oh, you look again, the expression for radio of like we don't need to talk about dentistry. How about just the legal issues?
I was like, I'm not. It's so funny with this one. I have a pretty low tolerance for blood and gore. This has resulted in a lot of what we're talking about. I have not actually seen because I'm looking away from the TV and just waiting till it's safe to look again. Because I'm not a fan of that. I respect it immensely for what it's doing for television in the Marvel universe. But personally, not a fan. Not a fan. I'll respect it, but not a fan.
Tooth injuries and eye injuries, and they're connected. No, that does not. Again, your expression could be a meme, priceless. Oh no, that bad. All right, so let's talk about the beginning of the episode, or close to the beginning, where Vanessa and Fisk have their trip to Red Hook, and there's a lot that happened with, again, wrong kind of couples therapy. Just not okay. And there's mention about the guy that they had killed. So there was a conspiracy to kill the tracksuit mob boss. So that's now known. But Your Honor, are these your notes for Vanessa ascending to the throne?
Yes.
Help us understand.
So I loved Vanessa's line when talking about the other gang leader, saying he was a punk aiming for a throne, this was a very effective session of marriage counseling, because I think at the end of this particular session, Vanessa and the kingpin are firmly aligned. But the most interesting part of this segment is when he brings her to the apartment where Adam is being held, and she gets to see that he has been holding Adam prisoner, and they there's basically both a key and a gun available to Vanessa, and Vanessa chooses the gun, and she kills Adam while he's in the cage. So this would clearly be murder in the second degree, because it was intent to cause the death of another person, because she pointed the gun and shot it at pretty close range a couple of times, and Adam apparently was dead. And in as much as the kingpin was the person who set up the gun being present, and Adam being in a jail cell unable to defend himself, he would be guilty probably of conspiracy in the second degree, a Class B felony, which we've discussed previously, which is Section 105.15 of our penal law. So this was a really well done scene, showing the evilness of Vanessa and Kingpin, and the reestablishment of their strong union.
So while I would think the term dungeon would apply, the fact you used the word apartment gives me concern about what apartments are like in New York.
It was an apartment with a side dungeon.
Okay, it's just some have escape rooms.
Yeah.
Uh,
There's a lot of strange buildings here in the New England tri-state area, Josh.
well, we
There's
can,
just odd old buildings.
again, there could be a road trip. I mean, we got missions, but it's different.
Yeah, I'll digress on that issue. Where I lived in Massachusetts, there was a lot of houses from the Revolutionary War period, and a friend of mine had a house that was built in the 1750s, 1760s, and they were doing some renovation of their basement, and their basement was all stones. And when they got to a particular wall, it turned out to be a fake wall, and behind it was a door, and there was a tunnel, and the tunnel ran all the way a good probably 800-900 feet to another house that was built around the same time. And in that tunnel was a cache of muskets, uh, bullets, or all from Revolutionary times. It was clearly a Minuteman, hiding place for revolutionary soldiers. So yeah, you do have some of those crazy things up in New England.
Yeah, our gold rush experience left its mark on the state, but it's different. Or the building of the LA freeways, different, with our urban sprawl. So again, just very different regional history. And nothing explains it more like water rights, because that's a big thing out here. But what else is a big thing is the notes about Dr. Glenn, who had a rough day. Like she's understandably upset about her experience, and she starts making comments about Muse and Daredevil being connected, and they're just boys playing in masks. And this is where Matt learns that Fiska is one of his girlfriend's patients, and there's an invitation to the ball because apparently she's being watched, and that's kind of upsetting. So, who? Okay, Your Honor, why don't you? Oh, Gabby, take it away, Gabby.
Yeah, no, it's funny because she never actually confirms that Fisk is a patient. Because, and I had this later on in the notes because, you know, obviously Matt continues to push her to really confirm that Fisk is a patient, and she keeps saying, I can neither confirm nor deny, or something along those lines. And what she's invoking is obviously HIPAA, right? Is the HIPAA privacy rule, which and other kind of code of ethics and confidentiality, which we talked about, but particularly HIPAA, which limits the circumstances under which an individual's protected health information may be used or disclosed by covered entities. And so generally a covered entity may not use or disclose protected health information, except in certain exceptions. One of the big ones is called TPO, which is treatment, payment, or operations. Obviously as the individual allows, that's why you have kind of privacy authorization forms when you go to the doctors. And I thought this was interesting because there's some other, like, I would say random exceptions, right? It's not random, it's kind of state and national policies that have been implemented into this rule because, again, HIPAA is a federal law. And there's one exception under these kind of national purposes, right? That is serious threat to health or safety. Covered entities may disclose protected health information that they believe is necessary to prevent or lessen a serious and imminent threat to a person or the public when such disclosure is made to someone they believe can prevent or lessen the threat, including the target of the threat. So this is interesting because we talked about one of the last times that in certain situations, psychologists and mental health professionals had to are mandated reporters and had to disclose certain information specifically to government authorities, right? Here, that is not the case. They have to just report it to someone that they believe can prevent or lessen the threat, which in the Marvel universe could be somebody like a vigilante, right? So obviously at this point, Heather does not know that Matt is Daredevil, but if she did know and believed that there was a threat posed by Kingpin, especially if she feels that her life is under threat or something like that, she may be able to fall into that exception. And then what I thought was also interesting is she's invited to this ball and she does not have any objections to going. I obviously it's a time to dress up and it's fun, but there are under the New York professional practice guidelines, which is not, you know, necessarily a form of governing law, for psychologists is, and this is generally, if you look at like the American Psychological Association, psychologists are really discouraged from socializing, right, in non-clinical settings with their patients, right? There are certain exceptions, you know, if the psychologist lives in like a rural area, right, and they have to go to the grocery store and the grocer is also their client, right? You can't kind of get out of that, right? But here, I think a kind of ethics board may say, yeah, you may not go to the fundraising gala of one of your clients where you know your client is going to be, right? And she really has no other reason for going, except obviously Fisk is trying to, you know, kind of do a kind of gamesmanship with Matt and let Matt know that he's watching her. But there's really no clinical purpose for her to go to this event or any other kind of related a reason for going to this event, and it really might impact, and that's really the key test, if it impacts her impartiality and ability to provide clinical services to her patient.
Yeah, because it's fun is not a good reason. It's just no, just no. It's one thing. I'm sure we could come up with hypotheticals where it would be okay. Uh, but this does seem to be skating into bad territory. Your Honor, any thoughts?
Yeah, no, I agree that you know, it probably would have been the best course of action to not go to such a thing where both of your clients are going to be. I found the conversation that was leading up to the receiving of the invitation about Dr. Glenn's opinions of vigilantes to be quite important because I'm sure that's what's going to lead to the downfall of this relationship. But other than that, nothing to add.
but she had a bad day.
She
Like
had a she had a beyond a bad day. Yeah,
yeah,
and it certainly was, some masked people that were causing that bad day.
yeah. So she might have realized she might change her view upon some reflection, getting away from the incident. But again, this is the world that half the population died, then a bunch of heroes got half the population resurrected. So, like, does she really feel that way? Uh, it seems to be ignoring what's been going on for like 15 years in this world of you have superheroes and
Yeah,
maybe
but what we also see from all the various movies, that there is a large segment of the population that is against the superheroes, and maybe that lessened after they saved all those people that disappeared. But there was a lot of politicians that were certainly feeding the public opinion against superheroes, against mutants, against vigilantes. So I'm sure there's still a very large segment of the population that has adopted that position, and probably won't change that position even if some of them were later saved.
yeah, but it's still a glass house situation of are you sure? But if you've just been someone tried to murder you, I understand being upset, especially if it's the next day or 36 hours later. But this then brings in the question, is Daredevil Born Again a sequel to Spin City? So because when you have the deputy mayor of communications, that was Michael J. Fox in Spin City. So it just made me wonder. It's like, are they going there? Like, is this the thing? And but we have some thoughts about one, does the mayor appoint deputy mayors? And two, how does that actually work? And Gabby, as our resident expert for local government, walk us through.
Yes. First of all, I felt very vindicated to have an appointed comms person actually mentioned, because it's been very vague what all of their staff positions are in the office, and that sometimes happens when you're talking about especially appointed positions. You serve multiple functions, and can have you don't introduce yourself by your title every time. So, but to get here comms mentioned was really exciting. And so Daniel is obviously appointed deputy mayor of communications, or for communications, which is actually, from what I was looking at, I did a bit of a deep dive on New York City government kind of structure, which, as the judge mentioned earlier, New York City functions quite differently from, kind of more what we would, maybe smaller municipalities, right? That most folks might be more familiar with. Obviously, a lot of towns, a lot of municipalities have city councils, have a mayor, maybe a town manager, right? But because New York City is so large, the city council functions almost like its own form of like a legislative body, right? Because there are city councilors from all of the boroughs and all of the districts within New York City. And so that is kind of the city council. It's not just a couple of folks or, a smaller body. It's quite a large body. And then the mayor acts as a kind of veto power, kind of executive branch in relation to the city council. And so what I could find on this was all of these positions were actually laid out in Executive Order 45, which was done under the current mayoral administration back last year in last September. But under New York City Charter, Chapter 1, Section 7, the mayor does have the authority to appoint deputy mayors, and it doesn't specify which positions he has to appoint or not appoint. So he could theoretically create kind of endless deputy mayors. Um, And so the question becomes, though, is the deputy mayor for communications the right function of what he wants Daniel to do, which is to be his kind of voice with the city council? And while the deputy mayor does kind of advise with communication strategy, oversees, things like the Office of the Press Secretary, Office of Director of Communications, manages liaison with communication positions, and does have the ability to perform any function, power, or duty of the mayor in negotiating, executing, and delivering any agreements necessary to effectuate matters referred to in his job description. He can't actually represent the mayor, unlike some of the other deputy mayor positions, on any boards, committees, or commissions of which the mayor is a member. And the thing is, and maybe the judge can speak to this a little bit more, but typically in state government, you have a comms section of whatever level of government it is, and then you have a legislative, or in this case, the Office of Intergovernmental Affairs, of which there is a director of intergovernmental and external affairs who handles that kind of liaison role, right? And they work closely together. But that person is more experienced in policy development, in those sorts of matters, developing policies, advancing policies, negotiating policies, and other legislative things. And so that's really, I think, what Fisk wants him to do. It's not necessarily a comms strategy thing. So I think he appointed him to the wrong position, gives him a title with more weight. But I don't think he's going to actually be able to achieve Fisk's aims with the city council. Unless he does one heck of a social media campaign, then, he's got it all set for this Red Hook project.
Your Honor, any thoughts on local government?
In New York City, the geography to kind of plays a bit of a role in this. If when you walk into the City Hall building, if you walk to the left, you're in the mayoral wing, and his deputies have officers, and the mayor has their office. And if you walk to the right of the City Hall, you're in the council chamber and the council offices. And in the middle, in the rotunda area, you have the speaker's office and the minority leader and the majority leader. And so there's a lot of fluidity with the deputy mayors, and they change the names of them every so often, depending on the mayor and what he wants to do. That's why it's done by executive order. There's the first deputy mayor that's kind of statutory, and that one is the one that takes the if the mayor is away for an extended period, the first deputy mayor has a lot of the mayor's powers. But the deputy mayors can be kind of used a little bit differently than their roles actually suggest. So it did not surprise me that he appointed him the mayor, the deputy mayor of communications, that would kind of put him in charge of a lot of things that he wouldn't necessarily be dealing with if he's going to just be dealing with the city council. But from previous experience, some of the deputy mayors for communications, their jobs not only was dealing with the press, but it was dealing with some of those intergovernmental issues as they did joint press releases and other things, because there's a lot of behind the scenes in that city hall work that's being done before they bring it out as to what they're going to be doing. So it didn't surprise me all that much. I think that it's a bit of a jump for him to jump to a deputy mayorship from the being a lackey during the campaign and then coming up and now being in charge of press secretaries and speech writing, and I don't see that happening. So I think maybe there was just he wanted to give him a title that was going to rub some people the wrong way and help him be in a position where others would take him seriously right away. But yeah, I think it would be a kind of a fluid position as to what he would actually be doing.
Sounds more than a press secretary, but
Yeah,
it's just different. And I don't know if any of our big three cities in the Bay Area have anything comparable. Because again, San Francisco, big, but confined. It can't grow. Um, San Jose is larger than Chicago. So that's probably the biggest. Oakland's substantial as well. And then we have all the other cities in between that vary in size. And so Piedmont is tiny. It's like our Luxembourg, and or Alameda is also small. But you get Sunnyvale, Mountain View, these capital Silicon Valley towns that are huge. So like a lot of people live there. So again, but I've that's a curious question. So one I've not seen. Moving on, we do have some law, office management, ethical issues of when you have a client come in for an interview. And I've never seen anyone be that disrespectful with, feet on the desk and like on the phone playing while talking. Um, I would not want to deal with that personally. And Matt kicks into cross-examination mode of the client, which I think is okay. Like, you need to be respectful because if you can't handle pressure from your own lawyer asking you hard questions, wait till you meet opposing counsel in a deposition and you're going to be tap dancing for your life because they will ask you mean, hard things, and you need to be ready for that. I mean, they'll still be respectful, but they're not everyone's the polite professional problem solver. There are those who swing a axe in depo and can hurt your feelings. So ethical issues with this because Matt calls his client a liar, embezzled from teachers, or defrauded them, did bad things to teachers, and they're stuck representing this bozo who is entitled to a robust defense. Your Honor, did you take it away?
So yeah, the potential client or the new client basically says that he would have no problem taking the stand and lying. And this deals with the issue of can a lawyer knowingly put someone on the stand who is going to lie? And the answer to that is ethically, no, you can't do that. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement or material fact or law previously made to the tribunal by the lawyer. And this is Rule 3.3 of our ethics code in New York. It goes on to say that if a lawyer, the lawyer's client or witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal, which is the court. A lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that the lawyer reasonably believes is false. And this does set up a difference between a civil case and a criminal case. In a civil case, you would not be permitted to have the lying witness take the stand at all. The lawyer would not be able to put them on the stand and offer that false testimony. But there is the interplay of a defendant's right to testify at a criminal trial. So there is a situation where a defendant who a lawyer knows is going to lie would still have to put his client on the stand. And the answer to what you have to do has developed over the years of lots of case law. One of the better laid out cases is the case of People versus DePallo, DEPALLO, which was a Second Department case in New York that arose out of a Staten Island case, and the lawyer is kept out of the decision to protect his identity. I happened to know this case and the lawyer whose identity was being protected, and that was a very, very, very ethical attorney. And he basically went to the court to say, listen, my client wants to testify. He's going to not tell the truth. And the appeal was over whether or not this lawyer was ineffective in his counsel, and the appellate division said that he was effective in his counsel. And it boils down to this: if a lawyer is handling a criminal case in New York, and they understand that they're dealing with a client who intends to perjure themselves, the lawyer has to tell the court without telling any particular details as to what is going to be lied, what is a lie, what is the true. You then ask permission to present the defendant's false testimony using the narrative method. And I'll get into that in a second. And then when it comes time for your closing argument, you're not allowed to refer to your client's testimony and the story that he gave. You just ignore it like it never happened. And what the narrative method is most of us who are used to seeing television examinations on TV, and clearly those of us that are in a courtroom, most of the way that examination is done is a question answer, question answer, question answer, and that's the way testimony is done in the courts of this country. With a narrative method, you basically you put your client on the stand and you say, "What would you like to tell the jury?" And he goes through his entire story, and you don't participate it in any way. And then, of course, the prosecutor could cross-examine and have as much fun with that cross-examination that they can have. But you don't participate in that perjurious testimony, and that's what if. I don't see Matt and his partner probably taking this case, because if they know that their client is not someone that's truthful, it's probably not a good client to take. Granted, the firm is in need of some money, so his partner might have a different idea, but I don't see them taking the case. But if they were to take the case, if it's a civil embezzlement case, they wouldn't be allowed to partake in having this client take the stand at all if they know he's being perjurious. If it's a criminal case that he's being charged with embezzlement, and he still wanted to take the stand, it would have to be done through this narrative method.
That's what I remember from law school and being civil practice. I haven't had to encounter this for obvious reasons, but that's what I remember as well in discussing California's practice. So while I don't know the details, this sounds extremely familiar of the narrative approach, and not to participate in committing fraud upon the tribunal. But also you have to let your client testify in a criminal matter. So yeah, that's nasty. Gabby, any thoughts?
Yeah, and I think as the judge said, it gets to the heart of the kind of confidentiality, which is I think a bit weird for non-lawyers to understand, which is you can't just walk up to the court and say, these are all the things my client lied about, like this is all the things that are wrong, which is what like your moral instinct, right, is to just like say, no, he's a liar. This is what he's lying about, right? But you have to kind of, as the judge said, kind of share only what is necessary, right? And not the kind of narrative story part of it, but just say, he's going to perjure himself and whatever. So I think that's always an interesting thing that kind of gets overlooked when we talk about, the rules of disclosure to the court, right? It's not a all or nothing, right? It leans on usually nothing, or what I always remember from my ethics course in law school was you usually lean towards, if there's not a required disclosure to the court, it is recusing yourself, right? So that you cannot be a part of it anymore. And so it's kind of very different from kind of our normal moral rules of what we would think to disclose.
Yeah, and on that reclosure issue, that's kind of discussed in the Topalo case. It's not that easy to just say, I don't want to represent the defendant anymore, because then you're putting another lawyer in the exact same position or even worse, that lawyer doesn't know that the defendant's going to perjure themselves, and then they
Mm.
knowingly participate in that, or they unknowingly participate in that perjury. So in the case, the court actually said that recusal is not the answer to this kind of situation. He kind of has to stick with his client, and the narrative method is the best way to then go through that whole thing.
Well, then, and the other half of this is you have the DA that can give the cross-examination of a lifetime. And so if you want the Perry Mason moments for impeachment, there you go. And it can open the door in all kinds of fun and exciting ways for whether it's character evidence and just being able to rip the guy a new one uh, for, oh, you claim you have a reputation for being honest. Well, and start rolling out the forged checks or whatever the issue is. So that could be again good TV moments. But the the prospective client did straighten up. Like when Matt switched to cross-examine mode, like the feet came off the table and he presented okay, but you can't put a perjurer up. Just it's one thing to be wrong. It's like I made a mistake. That's one situation. And better to have I was confused with what you were talking about, or but it's another thing to go, yeah, he's just gonna get up there and lie. Um, yeah, it's being wrong is mistaken. And I think the best way for lay people to understand that kind of cross-examination is uh well, we'll save that for another time. But there are examples from pop culture that can be fun for another example. So, Gabby, are you about to say something?
No, I was going to say, I think, thinking of it afterwards of the episode is we continually see Matt getting continually frustrated with the kind of defense system, right? And, he even says, they babysit chaos, right? They're not actually doing anything, which is, I think the interesting line where, he had initially kind of completely given up his vigilantism, right, to handle things through the courts, right, to see how the courts handle things, and he's not really getting anywhere, especially as demonstrated by the case with the theft of the caramel corn, right? And I think all of this, and even the kind of ending, which I know we'll talk about in a second, is setting him up for that kind of plot line that we've talked about of him getting kind of switching sides, right, in terms of his lawyer capacity. So I just think that's all kind of where that may be leading up to, is for him to go on the opposite side and go into the kind of prosecutor side.
Yeah, and it's the setup for the end. Because I mean, like, let's get there. If you take a bullet for the mayor, there's going to be some political capital there. Also, I think the kingpin will dig it because you took a bullet for me. Like he while he has decapitated people and he's done all kinds of horrible things, there's a strong loyalty factor with him. And taking a bullet's probably one of those, okay, oh, my wife had your best friend killed. Oh no. Like he's gonna have some very conflicted feelings of, the guy that I have not liked just took a bullet for me. After I promised not to do harm, my wife had his best friend killed. I could see him being upset, and I can see that playing into Matt getting appointed DA or winning an election to be DA. So there's a lot there. But there's other things, either of you want to jump in on that?
Yeah,
Yeah,
no,
I
I agree that, it's clear that he was going to give the system its chance to do the right thing, and everywhere, and as every episode goes along, the system is failing him, both the political system and the criminal justice system. At this black and white ball, you have the kingpin bringing people into the office who kind of come out with their faces uh, drawn because they know that they've been beat, and people are being forced to support his Red Hook rebuilding plan. Uh, and the uh, his task force is using any and all means necessary in order to make sure that people follow what the mayor wants with regards to uh, his Red Hook rebuilding project. And so it really, I think, because Matt is hearing all of these conversations with his super hearing, and he you could see in his face, that it's another one against the system, another one against the system.
Gabby?
Yeah, no, and I think two things with that is what I found interesting of those closed door meetings, and I know we have this with the black and white ball notes, but you clearly see swordsmen come in, and it was a contrast, and to what the judge is saying, it's a contrast to what had been discussed in the mayor's office, right? That the ACLU, which is cool that the ACLU exists in the Marvel universe canon. Like, I have not checked out their social, but I hope they capitalize on that they exist canonically within the Marvel universe. So kudos to, I know a lot of great people over at the ACLU. Kudos to them that they are, doing the good work even in the Marvel Cinematic Universe. Um,
The fictional good work. So
yes, the fictional good work, right? So but what's interesting, because they mentioned the lawsuits, right, of how this task force, which, I don't know how many people are vigilantes in New York City, but, vigilanteism is down by 30%, which that could be two people, it could be four people. I think they mentioned like 15 lawsuits. So clearly that's, at least 15 people that have had their rights violated, or that could be people that were like roughed up by the police, right? Suspected of being vigilantes. But what you see with swordsmen is that clearly this task force is not equitably enforcing their mission, right? Because if they were, it is clearly known, at least by Fisk, who Jack Duquesne is, right? And so they could have picked him up, but he's using that as leverage for political kind of capital for this Red Hook project. So I really do find that kind of another fascinating tidbit there.
I so jacketing the shakedown to match public funds or put in private funds and then match public. Anyway, he's going to be contributing to a private or to a public project in order to keep his whatever vigilanteism he's doing has a secret. But it's like it's good to see Kate rubbed off on him that that the almost stepdaughter uh doing her Hawkeye life. He did wear a sword to the Christmas party. So after being, released on charges of killing a man with a sword. So good for him. Good for him. Uh, but again, shakedown, we also see the task force start getting into full-on Gestapo KGB type tactics and ignoring the police commissioner. Like they burn a guy's hand, member of the press, and well, sure, it might be a no phones event because they don't want pictures. Okay. And that doesn't give you the license to start torturing people. And just to make a point, and then to tell the guy in charge, go pound sand. So there's issues there. Um,
Which, to answer his metaphorical question, both of those were assault. He did not need to put the guy's hand in oil for it to be assault. It was assault from the jump. So the police commissioner was right. It was assault and battery. The officer Powell was not correct. It had been assault and battery and
yeah,
undue force.
yeah, go ahead, file the complaint still. I mean, like, knock the butthead down a point. Also, you just assaulted a member of the press. Don't pick fights with people who buy ink by the barrel. And especially now there's evidence of the guy's maimed hand. Okay, go for it. Fight the fight. So Yeah, just very evil. Either of you want to comment on BB? We actually learned that she's not a puppet, and she has way more tenacity in line with her uncle.
And it's going to be interesting to see what her and the commissioner working together are able to accomplish.
Yeah, and I think it is interesting though, again, this was an episode that we did not see her BB report. So she has, I know she says that she publishes obviously under a different name somewhere else. We still don't know where that is, how that is, what form that is. But clearly her BB report has been silenced because these are the two episodes that don't have that. So obviously that could be just a time issue, but I think, considering how it was squeezed in the previous episodes, I think that was purposely done to show that she had been, at least that part of her journalistic voice had been silenced.
Yeah, but she's playing the long game. She goes to the party with the newly appointed deputy mayor, and I mean she's playing him. So I don't. She has a good ground game, and though I like the fact she knows that the kingpin was the lead suspect in her uncle's death. So good for her. I I remember the swordsman being different in the comics. I want to say it was Hawkeye's first um, pseudonym or you know costume that he wore. I might be completely wrong on my old Avengers history, so I do need to look that up. But I remember the swordsman being different, so they might just be recycling the name. But again, it's been a couple decades since I read those books. Um, and raises the question how many vigilantes are running around. So, anything else for the good of the order tonight?
But by the sheer number of Marvel comics that exist, there's a lot of vigilantes.
Yeah, and different levels
Yes, yes.
of what they do. And sure, a lot of stories were based in New York because that's where the writers were. Like it's what they knew. It's before people started branching out for let's do a story in Chicago or San Francisco or LA. Yeah, I remember it's like the Champions were based in LA. So going way back. So again, and then we're the West Coast Avengers. Uh, so which Hawkeye was the leader, I think, for most of that. So again, different runs, different eras where they do branch out. So not everything is taking place in Manhattan. So, but with that, thank you all for tuning in. We have Easter coming up, also Star Wars Celebration for those who are going to Tokyo. So the last episode will come out while some of us are in Tokyo. And then there's Easter. So we won't record on Easter. Again, happy to have everybody over sometime, but not for that. And so we'll record after the holiday and after our trip. But everybody, wherever you are, stay safe, stay healthy, and stay geeky. Take care now.